Good afternoon, everyone. Stephanie Garces here with Pink Mike Leo Confessions. Today, we're talking about a very interesting topic. It's how do you disinherit a child, a spouse, a family member, perhaps it's even children from another marriage. There's a number of lists of people that you can disinherit, and especially from real estate. That is a big topic today, and we're going to talk a lot about that. So, real estate is a lot of the practice that we do outside of estate planning. So a lot of this stuff is within our wheelhouse, and it's very complex, and you certainly need the right people to help you along the way. But let's talk about this. So why would we want to do this? Well, look, people have a number of reasons why to disinherit someone from a will, from their assets, excluding them from receiving really your assets, your property that you worked really hard to get and maintain, perhaps. And it's often handled by an estate planning lawyer when you want to disinherit someone from some of the stuff that they may be entitled to if something happens to you. An estate planning lawyer, and particularly one that's familiar with real estate, is also really important to do this. Now, in this week's Peak Mike Leal Confessions, we're talking with myself about this topic because disinheritance is a process that happens, and many times people want to do this while they're living and they already thought about this but have to formally do it, and there's critical steps you have to take. So I want to welcome all the viewers today. We're coming back now in the new year, so happy new year to everybody. As you know, I'm attorney Stephanie Garces, owner of Garces Law Firm, where we help you prepare for the unexpected and help you plan for your future, especially when it comes to your assets. So that is what we do. And today we're discussing disinheritances, which is always interesting. And I personally think that these topics actually come up a lot. People feel comfortable talking about it, but us in practice talk about this all the time. And there's no better time than the present to do this and even consider doing this if this is something that you've talked about or thought about. So we're going to talk about how disinheritance works, how disinheriting comes with reason, with steps, and you should have the power to choose who to exclude from your will and from your assets and who you want to include. So if you want to prevent someone from having your assets or having even access to them or having even so much as an inch of anything that you own, if you want to include or exclude a will and making those revisions while you're living is good. So we'll talk about that so that the property that you have ends up in the right hands. So as I mentioned, including someone from a will is a lot more than just, not mentioning them. That is one of the biggest mistakes I want to put out there. A lot of people think, oh, well, I'm not going to include my youngest son in this estate plan because he's bad and he's been mean to me, or maybe you have a falling out. Perhaps they're irresponsible. There's a number of reasons why people exclude family members or even spouses, etc., from their estate plan. And when we talk about this, it's more than just not mentioning them. So there's countless of stories that I can share with like family members, mixed family members. When I say mixed, like mixed families, a lot of times people divorce and they get remarried, or perhaps they don't get remarried. They just have a life partner. And there's like a number of infinite ways you can slice and dice different family dynamics. But a lot of times when you don't mention someone as specifically disinheriting them in your estate plan, what ends up happening is that these ex-spouses or family members who maybe you're not too keen about, they end up having to enter into litigation when you're no longer here, fighting over your assets, fighting over what you've worked so hard for. And that's because they believe that they're entitled to something. So depending on what you have in place at the time you've passed away, it does matter. It does end up in litigation. And who wants that? That's really, really tough, not only for the living, but the people that are actually no longer here. Now everybody has to fight over what you have. So that's how you end up in what's called probate. So if there is someone that was not properly or not even disinherited at all from your estate plan, that's how your estate ends up in litigation, in probate. So just something to keep in mind when we're talking about this. So because these critical documents were not completed, that's really why you end up there. So it's really important to prevent these individuals who you want to disinherit to not be included with being a beneficiary of some of the stuff that you have. So I'm going to explain that today, and what needs to be considered are a couple of things to really understand the complexity of this and officially and formally exclude these individuals that we're talking about. So one of the considerations that we keep in mind is inventory of all documents, beneficiary statements, and the financial and insurance accounts. So when we work together, we certainly look at those things. We make sure that in the process, we are actively asking for those documents from our clients so we can actually review them. I can't tell you how many times people won't even remember who was on their beneficiary statement for that $1 million life insurance policy that exists. Or perhaps there's also retirement accounts that could be up for grabs because individuals are not named properly in those. Or I actually have seen a lot where someone will have a child, for example, that they've named as a beneficiary of some of their insurance policies, and perhaps they want to disinherit them. So here we are doing the estate plan, and then when we pull this information from them, it turns out that they were actually going to get that policy because it was never updated. So this is super, super important, and big considerations you should be thinking about when you're doing your estate plan, because everything has to make sense. Everything has to align. So that's kind of what we try to focus on. Outside of the legal things, we make sure we even take it a step further, and we look at everything that you have, your statements, your accounts, especially all the documents that you may have stored away and still have dust in them because you haven't really looked at them. So those are important. Another thing we think about a lot is previous history of access or rights granted to the person that you wish to exclude. So many times, if you've already have something in place, perhaps you have like powers of attorney letters, or you have a will in place. Maybe you have something that you already drafted in the past that already gives access to this individual to do certain things. Perhaps if you become incapacitated, which is what letters of powers of attorney do. And so we do review what you actively have. Whether or not it's old, we don't care. We just want to see what is the last thing that you have. So this is something to consider, because if we're talking about excluding, or we're talking about updating, or those types of terms, we always have to go back to what did you have when you created it initially. Because we talk about this a lot, but updating your estate plan every couple of years, or even taking a look at it, is always, always vital to making sure that your wishes are going to be upheld if anything happens to you. Because, life happens, things change. And if you're excluding someone now that you weren't excluding, 10, 15 years ago, you would certainly need to update your estate plan. So we do look at the history of the documents that are in place to make sure there's nothing missing, to make sure that the gaps aren't, left open, and that we have not left any stones unturned when it comes to that. So that's one of the things we talk about. So really familiarizing yourself with your estate plan is really what I'm getting at. So we actually also dive into the terms of these documents. There's a lot of different types of documents that exist. Without boring everyone that's watching today, some of the main ones are living trusts, or any sort of maybe you have a non-living, you have a revocable or irrevocable trust. Maybe you have powers of attorney, maybe you don't, living wills, all of this stuff we look at. So these all have to be established together. And particularly when we're talking about blended families, when we're talking about previous marriages that you've had, or even previous relationships where people are partners and they've named each other in their documents, but maybe they're no longer together, or someone has passed away. All of this matters because we do have to familiarize ourselves with what it was that was in place. So that is extremely important for those individuals that are going through that. There's also a number of documents that will require updating outside of just the will, the trust, beneficiary forms we talked about, but deeds. When we talk about real estate, this is complex. When we talk about real estate, it really depends on a number of things. One of the few things that we discuss when it comes to real estate is obviously the deed, the title to the home. So we look at the deed of the home, the property title. We look to see, have there been any transfers to the property? Have there been a person that has passed away that was on the deed that no longer is? So there's a lot of ownership records we go through the county, through some of the documentation you have. So these are documents that when we talk about real estate, we have to look at. And so we do real estate all the time. And we know very well that the most recent deed is really what dictates who is on title, meaning who is the owner, who has the right to do things with the property, whether it's to sell it or refinance or perhaps transfer the property somewhere else. So all of that matters because the deed, when it comes to real estate, has a lot to do with disinheriting or not being able to disinherit someone specifically from the real estate. So we do talk about that with people because we don't actually know what the position is of the real estate when you come to see us. But once you work with us, we certainly make sure that pull that information so that nothing is left in the abyss. And actually, I should mention too that many people, they don't even recall who is on the deed. So this is always interesting to me because perhaps you've been, or maybe I think, especially when we talk about our, grandma, grandpa, individuals that are elderly, they may not know who they bought the house with. I've had a number of people tell me that they've bought the house on their own and they believe they're the only ones that own the property. Well, when we pull the deed with the county, we actually have seen that there's been more than one person that has been in that property that's the owner. So that becomes a little bit complex because then we have to look at does the person on the deed have rights of survivorship? Or is it going to be what's called tenants in common, which is another way of holding property? So all of these terms really become important, and it really influences the way that we look at updating your things and perhaps disinheriting someone, or perhaps we talk about other options to make sure that we can meet your needs. So you do have to make sure that when you are doing this, you come to someone who's experienced with real estate, specifically when disinheriting somebody. So just something to keep in mind when we talk about this. So one of the other considerations is when do you actually notify your attorney that perhaps did your estate plan, or maybe someone that does estate planning that maybe you don't have an estate plan? When is a good time to get in contact? Well, the obvious answer is immediately. There's no better time than the present to even just request a consultation, which is free with us, to make sure that you know that what you have is up to date, or perhaps it's not up to date. Maybe you got it from an online source, which many people do. That doesn't necessarily mean that it's a full estate plan that actually serves the need that you have. Perhaps the form you have is outdated. It may actually not include some of the individuals that exist today. For example, maybe you had more children, or perhaps you have adopted children, or perhaps you have a second marriage. And again, everything changes. We know for a fact that nothing is really the same from when it was 10, 5, 20 years ago. We have a lot of people that come in here with estate plans that have been around for a very long time and don't even include, a new spouse, that sort of thing. So really, really immediately is the best time to notify an attorney, specifically estate planning attorney. Perhaps happen to know real estate, especially when we're talking about disinheriting someone from a property. So if you wish to exclude someone or something because your life has changed, don't wait any longer than you need to, because the process takes time to make sure that we do it right. And it really requires in-person signings. That does take time and effort. So I just want to recap really quickly for anyone that's just joining us. My name is attorney Stephanie Garces, owner of Garces Law Firm here in Arlington Heights, Illinois, where we help parents secure their legacy and prepare for the unexpected for many individuals. And today we're talking about life transitions. We're talking about disinheriting a family member, a spouse, a child. And we really try to help and educate everyone during this process to make sure that your legacy is protected in the event of an unexpected absence. So if you missed the last session, you can follow it on our Facebook page. We had a really, really good topic on that one. But for today's topic, we're talking about a challenging topic, one that not everyone wants to talk about, at least maybe not at a family dinner or something, but you certainly have been thinking it. So for those of you that have been thinking about it, how to disinherit a child, a spouse, a family member, and especially when it comes to real estate property, is something that we're talking about today. So you always can join us on Tuesdays at 1:00 Central Time to make sure you know what is up to date with what we're talking about. That way you can know, something that you didn't know before. So a lot of the viewers have questions, and I always welcome questions during the pink mic because people tend to be watching, and maybe you don't want to, call us with your question or set up a consultation because you're busy. But you can always pop in with questions during the chat below, and we love to see the questions, and you can even message us personally. So we'll be kind of tackling a couple of questions that we've got so far. Today we have a question that says, do I have to notify a person that I'm excluding from a will? That is a great question. In the practical answer is no, you don't have to notify anybody. You certainly don't want to say, hey, by the way, I don't really care to include you in my assets. Now, can you tell them? Sure, you can tell them whatever you want. But typically, no, you don't have to notify anybody formally. And the best practice is really just to think about what you're doing when you're doing this, because, just because you got in a fight with your spouse or your child, you should not rush to go do this. I mean, these are really serious decisions. So you don't have to notify the person, but you certainly want to think it through before you actually do this, because once you update the will and the estate plan and you've excluded this person from your assets and from your estate, in order for you to, put them back into the estate because you've reconciled your differences or whatever, then you have to redo the updates. So the updates take time. There's a lot of formal paperwork to actually do what's called an amendment or perhaps a reinstatement. The restatement is the one that talks about updating the entire trust. So we may have to do that if you already have something that's already there. If it's from scratch, we can still do it from scratch, but you don't have to notify the other person. So that's a really good question, and a one that I enjoy when people ask me that, because it's a good question. I don't think I'd ever think to notify someone, but the next question we have is, will they have to sign documents if I remove them? No, the answer is no. That's a great question too, because I think people think that if you're getting something updated, you have to get someone to come sign off. I would say the general answer is no, but keep in mind when we talk about spouses, when we talk about people that you're married with, it's a little bit more complex. It's not as easy of an answer because it really depends on the marriage and what exists. There's prenuptial agreements, postnuptial agreements that couples will have with their marriage. If you have one of those, the answer is it depends, because there are documents that exist that we have to review in the interim of trying to exclude a spouse, especially when you're married with them, because it may require them to consent to that. So it just depends, because it's hard to say it as a general blanket answer. But if we're talking about children or family member, typically the answer is no. They don't have to sign anything to be removed. Now, maybe if we're talking about a spouse or something to that effect, you'd want to see an attorney before you actually get an answer just from this pink mic, because that is very dependent on the circumstances. So keep in mind that you do want to check with your attorney when you're actually trying to do this, especially when it comes to a spouse, to make sure it's done properly and so you understand the process and what's involved. Another question that we get often is, how much do these updates cost? So if you already have an existing estate plan that you've had for many years, but perhaps you need to update it, we have to do a restatement, they call it, perhaps. Those are usually on an hourly basis, or we sometimes do them flat fee depending on what is required. Sometimes the updates will be minimal, which the cost is minimal, or it could be a whole new a trust, because it really depends on what you have. There's a range. I mean, it could be a flat fee, $300 if it's something simple, or it could be closer to like maybe 1,000, maybe 2,000, depending on how much time is required. So, they say the time is money. It's the same thing when it comes to the cost. So if you're requiring a bigger update, and maybe we're just actually stripping what you have and creating a whole new one that changes all of the terms, they may be more expensive in the long run, but it's certainly still worth it because it'll save you the hassle. If it's something more simple, like you want to change, for example, we have a client now that had to change the name of the children that are living because one of their children unfortunately passed away, and the husband has passed away. So we are sort of reallocating some of the assets. Whatever was going to their son is now going to someone else. So those things are not very costly, but it just depends on the circumstance. So that's a good question. The other question we get is, what if the financial institution requires signatures and acknowledgements? Now, when we talk about financial institutions, if you come around this topic and this is something that comes up, you certainly want to maybe call a timeout and call your attorney to see what exactly is being required to be signed. Because to be honest, it's hard to advise someone what they need to sign or not sign if it's something that we're not present for. So it's always a good idea to check with your attorney, especially the one that actually helped you with the estate planning documents, if possible, because you want to make sure that what the financial institution is asking you to sign is something that aligns with what we're actually setting to do with your estate plan. And I say this because, people that work at the financial institution, they have protocol, they have documents that they need signed. So it's never a bad idea to pick up the phone and consult with your attorney on that one, because we have to make sure that what you're signing is actually something that's appropriate, or perhaps it's inappropriate and it would maybe dismantle what we're trying to do with the estate plan, or perhaps even trying to maneuver with the financial institution. So definitely check with your attorney before you sign off on anything, if there was a requirement. But typically, it just depends on the bank. If there is something, that you certainly want to call us, but that's kind of the best answer for that one. Now, what if the person you're excluding is incapacitated? Is another question that we received. So in this scenario, if someone's incapacitated, it's not a bad idea to consider why you're excluding them, because many times if someone becomes incapacitated, for example, maybe someone you had in your estate plan is lacking capacity. Perhaps their health is declining, or they had a bad accident or something where they may never regain their capacity again. You could certainly do that. That is another reason why you want to update your estate plan, because whenever someone lacks capacity, they typically have, either they're going to have, it could be that they have a guardian, someone that's actually acting on their behalf and overseeing their affairs. It could be that they may just be in bad health. Maybe that is not the best person you want to leave some of your assets to if they were to predecease you, type of thing. So you can certainly do it, but you do have to consider and weigh out the options as to why are they incapacitated? Is it permanent? Is it temporary? And this is something you discuss with your attorney, because it's a big decision to exclude someone that has recently become incapacitated. If they've always been incapacitated, then again, there would be someone in place, perhaps even a guardian, to really oversee them. So this is a tough question, because you sort of have to decide if this makes sense and why. But you can certainly do it with updating your estate plan. It's no different than updating it because you wanted to change your assets to go to another beneficiary. So that's definitely something to consider, and definitely allowed. The other thing that we get a question a lot about is when we talk about blended families, different marriages that you have, how soon can I add my new spouse's children as beneficiaries? So the answer to that is, we're assuming that with that question, you have a new spouse, and perhaps you may or may not have an estate plan. But if you do, you can certainly make the change immediately. This is assuming that you've been, divorced from your previous spouse, and that you're remarried, and they have children. This is a lot to think about, because when we talk about different marriages, there may or may not be children from the first marriage. If there are, you'll want to create an estate plan that fits your needs. So you may consider how you want to leave your assets, whether it's to your children from your first marriage, or perhaps you didn't have any, now it's your spouse's children. But you can do that right away. And depending on the circumstances, and after a consultation with an attorney, you could even create your own trust as opposed to a joint trust with your new spouse. You could also do a joint trust with your new spouse if you decided to do that, and if that makes sense. So we do ask that you consult with an attorney when you talk about adding new children into the mix, a new spouse, that sort of thing, because we do have to consider if it makes sense for what you're trying to achieve. So you can certainly do it immediately, and I would tell you, don't wait on that, because again, when you're in another marriage and you have another spouse, there is a big reason right there and a big life event that you'll want to have the proper estate plan in place, especially when we talk about properties. We talked about properties a lot during this conversation, but real estate is important. Is the real estate that you have in your name only? Is it in your trust? Is it in your ex-spouse's trust? And those things matter. So we do always talk about, consulting with an attorney, specifically estate planning, real estate, to make sure that what you're actually doing makes sense in theory and that property continues to be protected. Because it's tough with properties. How was it bought? How was it being transferred? Do you have rights to the property? Do you not? All of that will matter. So we do consider real estate property just a big asset for many of our clients. The real estate is actually the biggest asset for them, meaning that's the thing, the most value that they own. That matters. So even though you may say, oh, well, my house is one of the assets I own, well, depending on the value of the home, there's still reason to protect it. So you could certainly add your spouse's children right away. But when it comes to the real estate, we'll also address that and make sure you're well aware of what to do with that. Also, we talk a lot about virtual consultations. We're still offering those. That hasn't changed at all. So if you do want to do a virtual consultation, we offer them for free and from the comfort of your own home. I mean, who does not want to do a consultation and not have to leave their desk or perhaps your couch, depending on where you're at. But we do offer virtual consultations. They are free, so you can always give us a call at any point. You do the consultation with myself. We also do on-site visits for anyone that wants to do that. Of course, with everything going on, we do require masks and all that good stuff. But certainly doing those free consultations in case you wanted to contact me about that. So make sure that you guys always put your questions in our chat to make sure you don't have any underlying questions that weren't addressed today. And we talked about real estate a lot. And keep in mind that real estate is something that is hard to maneuver if you really don't know what you're doing. It's not as easy as just moving someone off a deed or adding them on. I know a lot of people hear that and they say, oh, that's going to solve my problems, but not always. So we want to make sure that if you're disinheriting a child, spouse, family member, etc., from your estate plan, specifically in real estate, you definitely want to contact me today to make sure we can answer those questions and guide you to the best of our ability. So I always want to thank you guys for watching. Our viewers are very, very special to me because you're always giving me good feedback and always supporting us here. So we really appreciate that. And thank you, everyone, for those excellent questions. They really help us dive into what the viewers are thinking. So as I mentioned before, in my experience working with an attorney that does real estate and estate planning like myself can really help you navigate the conversation of disinheriting an ex-spouse, a family member, a child, which can be very difficult. And in short, we can help you with that. We can be the mediators. We can be the guy that you need to really put this in place, which eases the stress of the situation and achieves your goals. So this year is the year of trying to get everything done. I know a lot of people are sitting at home now, working from home, and this may pop in your mind, but get your estate plans done if you haven't already, and please update them if you haven't checked. Just take the time to meet with us, and we're happy to do that. So I invite you to join me again next week for Pink Mike Legal Confessions. Same time, safe place, as always, and please feel free to share your recordings with your family members, especially those that can't add their questions during the live. You can always message us personally. So thank you so much for your time and be well.